ACSN first webinar on minority shareholders' rights. The ASEAN Company Secretaries Network is proud to bring together experts from the region to share perspectives about how minority shareholders' rights are respected and enforced or have remedies available in each of these countries. So we have today Singapore, Indonesia, Thailand, and Hong Kong.
How do I know whether we are not mute yet, right? You can hear us, huh?
Yes, we can hear you. So can the rest of the participants.
Very good. Is that?
Yes. Okay, permit me to begin. I'll share perspectives from Singapore and try and cover it in about 8 minutes. So what we're concerned about for minority shareholder rights is mechanisms that exist for fairness. Although in Singapore, we're going to go for elections if there are 3 candidates for the reserved presidential election shortly in 23rd September. Unlike democracy in the corporate world, it is on capitalistic principles, which means not one person, one vote, but whoever has more shares has more votes, which leads to the situation of majority shareholders dominating and minority shareholders can sometimes feel that they are slighted. The unique context is in the area of family businesses, which predominate in the rest of the world, in Asia in particular, where it's known to have something like 80% of the listed companies are family owned. But as they say, who says life is fair? Okay, there are similarities across the jurisdictions because it has to deal with who is the right person to sue the company or to sue the company. And in the past, you have a common law approach on the proper plaintiff. And right now in Singapore, we have this remedy under Section 216A. On the right-hand side, you have remedies for abuse by the majority called oppression by the on the minority. So there are some approaches that are available. Firstly, you can always exercise your normal shareholder rights. Second group remedies are those permitted by the courts. And the third one, the company remedies under the Companies Act. So let's go through some of them. Okay, minority shareholders have rights, the same rights as ordinary shareholders to information, which means your annual report. And you have the right to attend, vote, and call for general meetings of the company. But if you are in the minority, then your rights will be curtailed unless you can recruit other shareholders to your point of view in order to pass resolutions at general meetings. And that's where the frustration lies. Section 216 of the Companies Act provides the shareholders the rights to apply to court for assistance where the affairs are being conducted in ways that are oppressive to one or more shareholders or in disregard of his or their interests as shareholders. So the first limb has to do with the affairs of the company. The second limb, which gives assistance to the shareholder, is when some act of the company has been done or threatened, or some resolution of the shareholders has been passed that is prejudicial to one or more of the shareholders. Here you have to show that the act or resolution is going to prejudice one or more shareholders, including the minority shareholder who is making the application. In addition to Section 216, of course, the shareholder could also try and seek to wind up the company on just and equitable grounds. And this may be pertinent in the case of smaller private companies where when the founders first came together, they functioned like a partnership. And then now the majority have acted in a way that prejudices or oppresses the minority. And here you can seek to wind up the company under section 254(1)(f). Alternatively, you also have under section 409A, you can apply for a court injunction when you know a person is engaged or is engaging in conduct which contravenes the act, or where a person refuses to do what is required under the act. The interesting thing is that shareholders are getting to be more educated and more aware of their rights. And they ask management questions. And they expect boards to be held accountable for their actions. Be that as it may, the number of cases that come to court and the number of opportunities where rights for the minority are receiving attention are limited because it's costly to get access to correct the wrongs. Unless one gives more power to the regulators, all the remedies we've talked of earlier, even calling for a general meeting, the cost of the requisition general meeting lies with the shareholders who requisition it, which means the minority shareholders who manage to achieve the threshold required for a requisitioned general meeting will have to pay for the meeting first. If the minority shareholder seeks to wind up the company, there are legal fees involved. If you seek to go under section 216, similarly, someone has to make the application and pay for it. And this has implications and challenges, especially when you have an emphasis on startups and innovation. Because in every startup, there will be a group that will be the majority, and another group that will be minority. Of course, there is the other possible remedy, which is called extra legal remedies outside of the courtroom, where you could, if the statements made do not lead to defamation suits, you could try and use social media and bring things to bear on reputations of individuals to try and seek the action that you want. As the case example of the Hong Fook case illustrates. Hong Fook was a listed company in the real estate industry, and you have 5 family members. One serves as chairman and CEO, and 4 were in senior management. They received directors' fees and salaries. There was no nominations committee, no remuneration committee at that time. No dividends were declared from 2007 to 2012, although the company was making profits. And the real question was, right in the middle of the general meeting, the chairman switches from the mode of voting from show of hands to poll. And this was in the days before poll became a requirement. So disgruntled minority took to media and social media after the AGM. One minority shareholder developed a website called Hong Fook Minorities on WordPress in May 2012. Then the newspaper Business Times published an article on the matter of the director's remuneration on 28th of April. SGX then came in to ask the company to post the AGM minutes on the website. But the company declined. Minority shareholders posted on the Hong Fook website in June that cumulative remuneration paid to the 4 directors, executive directors from 2007 to 2011 amounted to 43 million, almost 3.23 times the cumulative company's profit after tax, after excluding revaluation gains and losses. So all these are just attempts to use social media to get to changes on behavior. The aftermath, on 31st July 2012, Hong Fook announced that one of the family members serving as vice president for property maintenance resigned to pursue other interests. The company also declared a dividend, which is what the minority was asking for. And on 30th March 2013, Hong Fook announced it would appoint new independent directors. And since then, there have been changes. So this brief this brief account is a brief account of Singapore's state of affairs and sources of remedies available in respect of minority shareholder rights, done in hopefully 8 minutes or less. I'm now going to hand over to the next person, and so I'm going to stop sharing my screen. I'm going to turn off my video after I introduce and call our next presenter. I'm going to call Dr. Hadijanto Saroso. He's chairman of Indonesian Company Secretaries Association. Interestingly, ICSA. So, Pak Hadi, can you take over now and share the position in Indonesia? Pak Hadi, we cannot hear you. Can you start? You may start now.
Okay, Dr. Tan, can you hear me now?
Yes, please begin. Thank you very much.
Okay, thank you. Thank you, everybody. Hi, this is Hadijanto Saroso. I'm coming from Indonesia Professional Association. I broadcast from Binus University today. Today, I would like to share with you about an update of Indonesia Stock Exchange. Let me prepare the presentation slide. Okay, can everybody see my presentations? I hope everybody can see my presentations here. So, Indonesians...
Pak Hadi, you share out your screen because we cannot see the presentation.
Oh, okay. I think I have difficulties. Maybe wait a minute. Sorry. Okay, share. Okay, can you see now? Dr. Tan, everybody, can you see my presentations?
Yes, we can. We can. Thank you very much. Very good. Excellent.
Okay, I'm sorry for the delay. So basically, I would like to share with you about an update for Indonesian Stock Exchange and stock market regarding with the minority shareholder protections. If you take a look at the why Indonesia want to promote minority shareholder protections, because we believe that Indonesia is going to be very what do you call it? Can grow faster if everybody can join in the development of the country, including all the investors. Plus, of course, the minority shareholders. That's why it's the government and also all the industry in the stock exchange try to promote Indonesia as part of the economic pillars in ASEAN and also in the whole world. And if you take a look at the rating of ASEAN countries, in the last couple of months, it's a very pleased for the government that S&P has been released a new ratings for Indonesia, BBB-. It's actually giving opportunity for Indonesia to enter an investment grade for countries. If you take a look at Fitch, actually upgrade Indonesia to investment grade in December 2011, and Moody's in January 2012. So all the ratings company actually provide a good perspective that Indonesia is a good place to invest. And of course, this will help us also to strengthen the country in the regions to promote further about the investment in the region. Another things that I want to share with you that we are so pleased to say that Indonesia index growth in Jakarta Stock Exchange in the last 10 years is in the top position, which is if you invest a certain amount of money in Jakarta Stock Exchange, in Indonesia Stock Exchange, it will give you return very significant, is 223.5%. And that will, we hope that this possibility of growth can also strengthen the country such as Philippines, Thailand, everybody in ASEAN also. And if we move forward, the figures in Indonesia Stock Exchange, we are now still a little bit behind as compared with Indonesia, with the country in the regions. If you take a look at the number of listed company, only 557 listed company. But the market cap, I can say that the it will already reach 6,1073 trillions today, and market cap growth in compound aggregate rate is about 12 and 38%. If you compare with the GDP, it's actually 45%. I'm sorry, that's GDP in 2016, and average trading value is about 7.3 trillion. So it's a massive transaction happening today in stock exchange, Indonesia Stock Exchange, compared with, let's say, 10 years ago. Another things that I want to share with you is the domestic investor dominate actually the Indonesia Stock Exchange. It means that previously, let's say if you compare with 2013, 2014, and 2015, the number of investors, foreign investors actually dominate the transaction in Indonesia Stock Exchange. But now, because of the support of technology, the support of applications, online tradings in the stocks, and people start to believe that invest in a stock exchange give a good return. So that's why it seems like the domestic investors now start to invest in stock exchange, and the trend is getting higher and higher every year. This will please us and also stimulate other investors to join in Indonesia Stock Exchange. Of course, if we take a look at which industry actually give us give us a good attention in this stock exchange. If you take a look at the number of category of industry, bank actually dominate the company who want to enter in Indonesia Stock Exchange. The second one is property. Third one is energy, construction, furniture, that dominate in the last 3 years who entered in Indonesia Stock Exchange. If you take a look at the value, it's quite big, and that will give another possibility of investor to join the development of the company. So, if you take a look at the how the authority support this Indonesia Stock Exchange, if you take a look at in 2011, actually Indonesia entered in the new era of financial service authority. We used to have a single independent body for stock exchange, but now this financial authority is a combination between that control bank sectors and also non-bank sectors. So the new OJK, Otoritas Jasa Keuangan or Financial Service Authority, actually now control those two industries. If you take a look at the number of regulations that has been released by this authority, every year is also increasing. It means the concern and also the attention of the government and also attention of the regulatory about how we secure the investment, how we manage the investment in Indonesia is very high. Another things that I want to share that as a summary, that minority shareholder protection is about transparency, it's about involvement, it's about take decisions, good governance, monitoring. So these 5 factors actually give colors to the old regulations in Indonesia. I can share with you as an example of transparency. So transparency in Indonesia can be represented by providing an access to company information. If you take a look at now a new regulation of POJK number 8, that the company website must provide the information to all the investors, such as IPO data, annual report, financial report. So everybody, all investor can easily, find information about the company that they want to invest easily. The number 2 is POJK number 31, that the company must publish any material information to the public. Another information that really important also is that all information should be stated in annual report. So any corporate action, if you take a look at this, it's part of the transparency. Affiliated transactions, mature transaction, merger, and so on and so forth. You can see lots of things in this list, actually part of the mature information that needs to be put in the annual report, including stock split, dividend, the listing, and so on and so forth. If we take a look at continue the list, gain or loss significant contracts, new innovation, inventions, or new product that adds value to the company, repurchase or payment of debt security. There's a lot of lists that needs to be put in, all the information that will be put in annual report. So we hope that by providing this information, any investor can easily evaluate, give value to the company that they want to invest. Another thing that really important is involvement. Involvement is with the new regulation POJK number 32, any question and answer in AGM has to be stated, has to be published, available to the public, because we used to have, we don't have this kind of information to people, but now by complying this regulation POJK number 32, all company that has AGM, any question and answer that happens during the AGM needs to be published, that available for all public, especially micro investors that is not don't attend in the AGM. Another thing that involvement is by empowering good corporate governance. Another regulations POJK 34 number 2014 that the company should explain the process of nomination and remunerations. And another thing is that in our governance structures, of course, the IDX now standardized the e-reporting. And with the regulation number 13, the audit committee should submit a report that relates to how we select the public accountants. So this is the latest regulations that bring more involvement in the government, good governance structures in the company to support the protection of minority shareholders. Another thing is that are very important, I think, take decisions, that minority shareholders should take decisions by asking approval from minority shareholders, especially that during any, what we call it, transaction that relates to conflict of interest. Any conflict of interest transaction that needs to be executed in one or two corporate actions, during the AGM, minority shareholders should take decision whether the transaction should be continued or not. Another thing that has been in progress now, the Indonesia Central Security Depository initiate e-voting. Of course, e-voting still because we need to set up an adjustment in several laws. But of course, this the spirit of how we want to protect the minority shareholder is there. So we hope that once we finish setting up the regulation, we hope that the e-voting will be available in a very short term. Another thing that is a very important how we protect the minority shareholders is a good governance. Of course, by implementing good governance, especially the report mechanism, like in insurance, bank, venture capital listed company, there's a lot of rules that needs to be fulfilled. And of course, especially the new regulation in 2014, the corporate secretary helps the management in implementing good governance. And this is a new era also for corporate secretary in Indonesia that become a corporate governance officer in the future. Another thing that are new for Indonesia also is comply and explain. So any regulations that relates to governance or any activities that relates to the governance that you're not compliant, you should explain. But you need to explain it in annual report. So these activities, of course, will help the company to protect and also protect the minority shareholders. Another thing that very important also is the monitoring mechanism. Monitoring mechanisms There is rules number 6 2015 about regular reporting for bank, and regular number 55 for insurance, and regulatory number 29 for annual report, and so on and so forth. There's a lot of regulations that relates to regular reporting, plus media. Of course, media become a very important mechanism in protecting minority shareholders, because media always been monitoring the activities of all the company, and the company will give the times to explain, especially when one of the regulations we call the public expose. So there is a mandatory public expose once in a year, but the company can actually add more public expose if the regulator requests for a certain issue. So by developing these regulations, we hope that we continue marking a positive trend in Indonesian Stock Exchange, and we hope that give benefits to the minority. Thank you very much.
Thank you, Pak Hadi.
Thank you.
Right, now I'm going to hand the time over. Pak Hadi, you have to mute the microphone. And you have to stop the screen sharing. Okay. Pak Hadi, can you mute the microphone?
Okay, thank you.
Thank you. Now I'm going to introduce Ms. Siu Chuan, FCIS, who's immediate past president of the Chartered Secretaries Malaysia, and ask her to share the situation in Malaysia regarding minority shareholders. Siu Chuan.
Thank you.
Please share out your screen.
Thank you, William. Thank you, William. Okay, hear me clear?
Yes, we can hear you.
Yeah, hi, I'm Siu Chuan from Malaysia. Today I will share with you the Malaysian chapter on the minority shareholders' rights. Okay, you will know that we recently have a new act, and there are also some addition inside. Also, we have a new code. So let me just share the screen first. So hopefully everyone can see.
Not yet. Your screen is not showing yet.
Is it up? I have put it up already. Can you see?
No, I can hear you, but I cannot see your screen. You'll see the green button on the left-hand side. Click that one.
Yeah. Okay, got it?
Ah, yes. Now we can. Thank you. You can go to full screen also.
Okay, thank you. Right. Okay, so briefly overview who is the shareholders, nature of the shareholders' rights, law affecting rights of shareholders for private companies, company legislation covering minor shareholders' right to provide for private companies, statutory directed actions for shareholders, and insolvency law and security law, additional rules for listed company. So I will cover briefly for both listed and unlisted. So I won't go into details who is the shareholders. It's just the extract from the definition in interest of time. So briefly, nature of shareholders' rights that we have in Malaysia. Shareholders' right can be broadly divided into three main rights. Rights to control and management, proprietary rights, and remedial and ancillary rights. Okay, I'll go into detail for each of them. Nature of shareholders' rights, so rights to control and management. So we have a few provisions under section 293, 294, and 334 specifically provide for the rights of shareholders to vote in person or by proxies. Okay, of course, corporate rep is also considered voting in person. And in addition, the voting rights for elections of directors, typically for the listed co or the Berhad companies where at the AGM, there are specific provisions as to how the shareholders could exercise their right, and that will cover, of course, the majority as well as the minority shareholders in terms of elections of directors, auditors, and also to attend the meeting as well as speak at the general meetings. And voting rights for amending constitution is also provided in addition to many other provisions in the new act. Actually, in addition to that, we have a new provisions where the shareholders have the right to participate as well as management review, so to speak. Of course, there's a check and balance, as in they have to make sure that it's in the best interest of the company, and they have to secure 75% votes. So there are some provision in that area. But similar to Singapore, where unlike the elections, we have one person, one vote. Here is one vote for every share held. So the majority shareholder would naturally have a bigger say in the voting rights of the company. And at the same time, we have also now make it mandatory for poll voting for the listed entity here. We started that July, actually last year, and we have actually gone 1 year full-blown voting by poll, and it so far worked pretty well. We are, unlike Indonesia, you are moving into electronic e-voting. We are only reaching poll voting at this stage as we speak. And proxies entitled to attend the meeting in the past used to be by show of hand, now will be all by poll. And voting rights for election of directors, auditors, and so on are all stipulated and prescribed in the Act, even if it's not provided in the company's memorandum or article associations. Now it's called constitutions in the new Act. Okay. Moving on, rights of shareholders in terms of proprietary rights. Rights to dividend, okay, is provided in the old Act and it further enhanced in the new Act. And in fact, in the new Act, there is a provision for clawback. For listed company, should the director make a wrong declarations payment of dividend for the company. Of course, before the directors could make the payment of dividend, they have to make a test. They will pass a test, a solvency test, that their company is able to pay its debt within 12 months from date of payment. From the date of payment. Of course, it's our profit the company, as in the old Act, in addition to the current Act. So should the director make a wrong declarations, then they will have to, the shareholder with the right to, the company with the right to claw back that payment from the directors individually as well as jointly. And in addition to that, the exchange has provisions, listing requirement provision that the payment has been made within 3 months from the declaration date. So this is normally at the moment which being addressed by the authorities. Okay, rights to participate distribution of assets on liquidation. That is very similar to Singapore, where there are rights to liquidate the company with 70% votes and so on, whether voluntary, otherwise. They would have rights to participate in terms of their dividends and return of capital. And in the new Act, there's also a provision for preemptive rights, which we didn't have it in the old Act, but now we have it in the new Act. Some technical glitch, currently can't see the slide, so let's try to get the slide back. Bear with us for a while. Is it better now? Is it okay? I have you on full screen. Let me move on in interest of time. Nature of shareholders' right in terms of remedial and ancillary rights. So they have right to information and inspection from books. This has always been in the old Act and is also in the new Act. So the rights for information, records of resolution, minutes for inspections at the registered office of the company without charge. Right to maintain representative derivative suit, section 2346. A member may apply to court for remedy in case of oppression. So we have something similar to Singapore in terms of operation rights, minority operation rights. Okay. The other things that we have in the new act, which is very similar. Okay, sorry, before I move on to that, in terms of social media, I heard from Singapore as well as Indonesia. Here, social media also play a very important role in addressing and voicing the rights of the minority shareholders. We have seen cases of listed company where re-elections of directors were not put through because the minority shareholders objected to it. We also have a very active NGO where it is called Minority Shareholders Watchdog Group. They voice the interests of the minority shareholders, and typically at most big companies, listed companies, AGM, they would submit questions after they have received and reviewed the annual reports plus all the announcements made by the listed entities, and the company would then respond to the question raised, as well as project the question raised and respond to the Minority Shareholders Watchdog Group for the benefits of the rest of the minority shareholders. And this has been there for some time and is getting more prominent currently. And in addition to that, we have also, the stock exchange have also introduced a two-tier votings for reappointment of independent director to remain independent on the board for listed company if they have served as independent directors for more than 12 years. So this is another new area that will give the minority shareholders a bigger voice. Moving on. Can you see? Okay. Moving, company legislation covering minority shareholders' rights for private company. This is for more on private company. For private company, they could do by way of written resolutions that make it simpler without having to call a meeting. And also it's make it easier in the new act for the Companies Act 2016, as you can see from the screen. I hope so. Sorry. On the screen, easier to convene shareholders meeting. Shareholders' right to management review. There's provision under section 195, where the shareholders have the right to make comments and make suggestions, of course, in the best interest of the company, in terms of the management of the company, and also able to pass resolution if they are able to secure the number of votes. So this is a new area, and it is yet to be seen. There were a bit of concern by the board and major shareholders when this was first introduced. But if you look into the detail of the drafting of the act, they are actually check and balance. So I don't think there will be any concerns or any abuse of these new provisions. And also we have introduced new provisions in terms of approval of directors' benefits for the Berhad company, a listed company especially, where in the past they only need to get shareholders approval for directors' fees, but now it covers benefits. So benefit is actually a very wide area where they need to get shareholders approval before they could pay directors' benefits. And the operation remedy, which actually very similar to Singapore, I will also skip that in the interest of time. The other areas is let me skip this one. It's very similar to Singapore. Skip that. Insolvency, which I thought I want to share with the rest of all participants, that we actually have a new Insolvency Act, which is now replaced the Bankruptcy Act 1967. And there are actually major changes in this new Bankruptcy Act, which was we have received the Royal Assent on 10th of May and gazetted on 18th of May this year. And in this, this is because we have a serious problem in terms of young Malaysians. At least 22,000 Malaysians under the age of 35 have been declared bankrupt between the year 2011 to 2015. So because of that, they have made some changes, introductions to the Insolvency Act or the formerly Bankruptcy Act. Very briefly, there is the minimum threshold increase to make someone bankrupt from 30,000 ringgit to 50,000 to commence a bankruptcy proceeding. And also, they can appoint a nominee to compromise or get discounts on debts owed pre-bankruptcy. And also, the other problem that the social guarantor in the past will get into trouble being a guarantor, but now they have differentiate between social guarantor will get more protection and will not be liable and be charged or labeled as bankrupt. You know, if they are just social, like study loans and so on, those are the social guarantor. Creditors cannot declare you as bankrupt unless they proceed, they prove that your intent to defeat or delay or evade personal services when they serve the notice of bankruptcy. So consequent to this, now, what would be the consequences if someone is charged bankrupt, which is actually very serious because the passport is compounded and the person can't travel. And the person can't have credit cards, or even if they have credit cards, they limit it to 1,000 ringgit spending. So it's actually not practical. And assets and property will all be vested with the Director General of Immigration. All bank accounts will be frozen, and so on and so forth. Another area which I want to cover is the listed company, which most listed company will have to comply with is Capital Market and Services Act, the listing requirement, which is going to be revamped now. And we have just introduced the Malaysian Code on Corporate Governance, which is slightly different from the comply and explain. Now it's apply and explain, and they have now differentiated between tier 1 and tier 2, and also progressive implementations. So the bigger, large company will have to comply earlier as compared to the smaller ones. We also have a Financial Services Act 2013, which replaced our OBAFIA. So I think briefly that is what I can cover for Malaysia. It's within the time.
Thank you, Sichuan. Okay, now you have to mute the microphone.
Yes.
Okay. I'm going to take some time to allow Mr. Rongrak Panapikiku to get ready his presentation. He's the Senior Vice President of FWD Life Insurance Public Company Limited, and he's going to speak to us about the situation in Thailand. So while he's getting ready, those of you who have questions from the earlier presentations, if you're not using the chat to ask the questions to the speakers, you might just type in the chat and we will collate the questions and pose it to the panel after this.
Hello?
Yes. Yep. You need to share your screen.
Yep.
Thank you, Mr. Rongrak.
Okay.
It's all over to you now.
Okay. Thank you very much. Okay, let me start with the Thailand. Before I go to the right of the shareholder, I would like to introduce you the basic form of the company in Thailand. We have 3 forms of the company in Thailand. So the content that I would like to talk today is will cover type of the Thai corporate entity, fundamental right of shareholder, and the way that we protect the right of minority shareholder, and how the other country look about protecting minority investor in Thailand. First, we go to the type of Thai corporate entity. The type of Thai corporate entity, we have mainly 2 major types. First one we call private company limited, and second type we call public company limited. For the first type, private company limited, we also have 2 subtypes. First one we call current or existing form, which is the form that we have right now, is the private company limited. So normally, according to the law, this type of company need to have at least minimum 3 shareholders. And the name of company, you can notice from the name that they will have the name followed by company limited. This is the first type. And the further normally is called promoter. And capital will be divided into share. Each share must have equal par value at minimum of 5 baht per share. And no minimum number of directors at least, but you need to have at least 1 director. And capital will be divided into share. Each share must have equal par value at minimum of 5 baht per share. And no minimum number of directors at least, but you need to have at least 1 director. Hello? And this type of company is strictly prohibited from offering the share for sale to the public. Another type under the private company limited is we call a new special form. This is not yet effective because it is generally in the registration process. We call the company with one single shareholder. So this company is a very new type and it's still uncertain. We need to wait until the enactment of the new law that will govern this type of entity. So next type, I would like to move to the type of we call public company limited. For this type of entity, we also have two subtypes. First one we call is non-listed company. That means it's normal public company limited, whose shares are not publicly traded on the stock exchange. Another type we call listed company, whose shares are publicly traded on the stock exchange of Thailand. This is the key difference between these two subtypes. For the first type, that's the public company that is not listed on the stock exchange of Thailand. They will have the minimum shareholder of 15. And the name of the company, you can notice from the name that it will use the name followed by public company limited. And the capital also divided into shares similar to the private company limited. But the difference is that each share have equal par value, but there is no minimum par value per share. That means the par value can be any amount, but you need to have at least 0.01 baht per share. That is the minimum that you need to have. And the minimum number of directors is 5, but the maximum, there is no limit. So you can have up to 20 or 30, but normally we will have allowed 10. And the objective of the company is to sell share to the public. That is the key difference between public company from the private company limited. And the third subtype we call listed company. This type is their share different from the first one because their share are publicly traded on the stock exchange of Thailand. So apart from complying with the Public Limited Company Act, this type of entity needs also to comply with the Security Exchange Act. That means they not to comply with the Company Limited Act, but also they need to comply with the requirement under the
Everybody is not there.
Hello?
He's not moving.
Mr. Rongra, are you finished?
Oh, everybody is down. 1 hour, right?
Rongra, are you still there?
He left the group.
Hey?
He left the group.
Mr. Rongra, must have, he has cut off from the, he has been cut off from the connection. He's back now. Welcome back, Rongra. Welcome back.
Okay. Okay. Can you hear me?
Yes, Mr. Rongra, please continue.
Okay, I'm sorry.
We saw your screen just now. I know sometimes just now there's a drop from the connection.
Yep. Okay. Okay. First, I would like to talk about the property right of shareholder. It's similar to other country and other jurisdiction. It's the basic right of shareholder, such as the right to be covered as a shareholder, the right to receive a share certificate, and the right to transfer or dispose of their share, the right to receive profit, dividend, sharing, the right to subscribe newly issued share in case of there is the increase of the share capital in the company, and the right to receive return or sharing of assets upon dissolution or liquidation is the basic right of shareholder. The next one, oops, I cannot change this. Okay, the next one is the management right. That means the shareholder has the right to manage or control the company, the right to obtain sufficient information and timely information about the company in order for the shareholder to keep, monitor, or to control the company. And also, the shareholder has the right to monitor the management of the company board of directors, who are the representative of shareholder who have the authority to manage the company. These are the basic rights, and also they have the right to inspect value corporate document that they may ask from the company so that they can inspect the company. So next one is the right to seek a redress or remedy from the company in case there is something wrong or there is some damages happen to the company and that's not caused by the shareholder, but it's caused by the director who fail in manage the company. The shareholder has the right to file a lawsuit to revoke the resolution adopted in the general shareholder meeting in case the company failed to seek things, and the right to attempt the respective action against the shareholder, the lawsuit against the director instead of the company. The next one is the right to obtain a redress or reversion of shareholder right that may caused by the director or the company itself. So I would like to talk next about the shareholder right according to Thai law. For the private company auditory resolution, this is when simple majority votes, and in case of Thai voting has the vote. And the next one is the special resolution. We call it special resolution because the resolution to be adopted in this case need to pass by the vote not less than 3/4 of the total vote of shareholder attending the meeting and entitled to vote. And the matter to be adopted in this kind of special resolution is to amend the memorandum of association, to amend the article of association, or in case of the increase or decrease of digital capital, this is required to have the special resolution. So the control mechanism of the shareholder in the private company is depend on the percentage of their shareholding. In case the shareholder owning more than 75%, they have the absolute control over the company. So that means they can do anything. All the decisions that require to be adopted by the shareholder, if this shareholder have more than 25%, of course they can pass any resolution even in case of the special resolution. But if the number of shareholding that they have in the company is less than 25, but still more than 50%, this group of shareholders will be entitled to pass the simple resolution, as I mentioned earlier. But in case of special resolution, they will not be able to pass by themselves unless they get the cooperation from other shareholder and move down to another step. If it's the number of shareholding percentage is lower than 50, but it's still more than 25, the right they have is just to block the vote in case of another group of shareholders would like to pass a special resolution because they have more than 25. So as I mentioned earlier, in case of the special resolution, we need to have at least 3/4 to pass the resolution. So if you have more than 25, you can block those shareholders from passing a special resolution. But if you have below than 25 but more than 20, the right that you have is maybe just only to ask the company to convene the shareholder meeting to consider the matter that you think is important to be less to be considered by the shareholder meeting. Next, if you have the shareholding percentage in the private company less than 20%, you can do nothing unless you get the cooperation, or you can seek cooperation from other shareholder to have the percentage of shareholding up to 25, that you may have the right to convene the shareholder meeting. So let's move to another type. In case of the public company limited, the voting rule is different from the private company limited. We generally have 4 types of voting rule. First type is general case, that similar to the private company, that is majority vote of shareholder attending the meeting. That means it's just a simple majority vote. And the next type is extraordinary case. The vote that required to be adopted, the minimum is 3/4 of total vote of shareholder attending the meeting and entitled to vote. And the next case is the case of approve the director remuneration. In this case, you need to have the resolution to be adopted by not less than 2/3 of the total vote of shareholders in the meeting. So this is different from the second type, that in this case there is no the case of conflict of interest. Under Thai law, all shareholders, including the director, have the right to cast the vote to approve the director remuneration. The next one is about the removal of director. This is very difficult, and from my experience, I have never seen any public company can remove their director by exercise this provision, because it's very difficult to get the vote of the shareholder up to 3/4, and the 3/4 is must come from the shareholder holding share altogether, not less than a half of share owned by shareholder attending that meeting. So in practice, it's very difficult to get this kind of vote from the shareholder. So for the protection mechanism for shareholder of public company limited. So normally, in case of convening a shareholder meeting, we have the right, if you are the shareholder holding share up to 10%, you can request the company board to convene the extraordinary general meeting of shareholder. And if the board fails to do so, the shareholder can do it by themselves. And the quorum for general meeting of shareholder for the public company, the minimum quorum that we require is 25 shareholders. And those 25 shareholders must hold share in the aggregate not less than 1/3 of the total issue share. And next is about the right to propose agenda to the shareholder for consider. According to the law, it says that the shareholder holding altogether 5% of total issue share have the right to propose the share to be considered in the shareholder meeting. And in case you would like to revoke any resolution adopted in the general shareholder meeting, if you would like to revoke that resolution, the law says that you need to have to join with other shareholders to call up to 5 shareholders, and you have to holding the share up to 20%, or you have the shareholding up to 20%, either one. But the condition is that you need to file the lawsuit within 1 month after the date of the adoption of that resolution. And the right to inspect the performance of director, the law allows that either one or more director holding 20% share altogether can request the company, can request to the official registrar at the Ministry of Commerce to appoint an inspector to inspect the company business operation, as well as the performance of the director. And in case of the filing of the lawsuit, the shareholder has the right to filing the lawsuit against the company, as I mentioned earlier. So you may see that the degree of protection of minority shareholder in Thailand is different from the type of the company. If it's just only private company, the degree of protection is low. And for the public company limited, the degree of protection is higher, adjust to be higher. But if it is the listed company, that means we have a lot of minority shareholder, we have a lot of shareholder, the degree of protection minority shareholder will be the highest one. So when we see the index that do by the World Bank from the ease of doing business, you may see that the strength of minority investor protection in Thailand index is up to 6.7 from 10% index, and from the 10 point index. And the ease of shareholder to sue the index, we have up to 7 points. And in case of from the aspect of the shareholder governance index, we have 5.6 or 5.3. And in case of the ownership and control index, we have allowed 5. And the next one is the extent of the corporate transparency index that conducted by World Bank. We can achieve up to 7 points from the 10 point maximum. That's all from Thailand.
Okay, thank you, Mr. Rongrat. Now we will on to Hong Kong. Mr. will be speaking, and he is the Senior Director and Head of Technical and Research of the Hong Kong Chartered Secretaries. Mohan, when you're ready. Let me see. I will mute.
Yeah, I'm ready. Thank you. There's a little bit of delay here, and that's why there is a bit of time lag. Okay, I actually, before this conference, went out and quickly looked at the latest statistics. And it turns out that in Hong Kong, we've got over 1.3 million private companies and around 2,060 listed companies. In terms of market capitalization for the listed companies, we're looking at $4 trillion US. And Hong Kong is the #1 IPO jurisdiction in the world globally. Every day, our trade is close to $1 billion US. So you could see that, you know, in a market such as ours, we need a high degree of regulation. And this is a definitely regulated market. In that context, we actually proposed this particular topic of minority protection. And turning to these slides, I give you an overview. Okay, so this is the table of contents, and you will see that we have a number of areas that we're going to cover, and in fact, we're going to cover 8 areas. Now, given the time limitation, I will be very brief in going through these. In terms of Hong Kong sources of rules and regulation, I think like many common law jurisdictions, we have case law and also statutory law. So that for a particular issue, we actually have the judges and the common law system and the philosophy behind it controlling it. And definitely minority protection is a major issue. And in terms of the company's ordinance, it is applicable to all private companies in Hong Kong as well as listed companies incorporated in Hong Kong. For overseas company, if they have a place of business, they have to actually register in Hong Kong as well and subject to a number of reporting obligations. But then for the overseas private company, which are basically passive holding companies, the company's ordinance does not apply. But given the context that we've got over 1.3 million companies that are private companies in Hong Kong, all listed in Hong Kong as Hong Kong company, you could see that the company's ordinance is a powerful tool in the regulator's arsenal to regulate minority protection. The next thing is, if you want to list in Hong Kong, whether you're a Hong Kong company or an overseas company, you actually have to enter a listing agreement with the stock exchange. It is not an actual agreement, it's an undertaking to comply with certain agreement terms. And the listing rules set out higher levels of investor protections, including minority protection. The next thing that we have in Hong Kong is something called the Securities and Futures Ordinance. This relates to securities regulation for companies listed in Hong Kong. About Hong Kong company, in terms of new companies ordinance, this came into force in 2.14, and as I said, it regulates 1.3 million companies in Hong Kong. So the major issue is who's a shareholder. Now, the shareholder, basically the person listed in the books of the company as a shareholder. In Hong Kong law concept, we only look at registered shareholder, so the person that is registered in the books. Next year, there's actually going to be rules and regulations as to ultimate beneficial ownership. Whether this will impinge on the traditional rules is something that we have to wait and see. But basically, a shareholder right now is a registered shareholder, and the shareholder has rights against the company and also amongst themselves to enforce the provisions of the article. This is where there is a major source of minority protection rights, because any shareholders could actually go and look at the articles and say that, well, these are my rights, and company, you're not fulfilling it, and we want you to fulfill it. Not only that, they actually have a lot of backing under the company's ordinance to help them fulfill those rights. One interesting question that arises is it permissible for certain shareholders to have additional rights? And the answer is yes and no. Yes, in the terms of private companies, if you are a shareholder in a private company, the articles govern your rights, and therefore you could be given additional rights or lesser rights with other classes of shareholders. That is purely a constitutional arrangement. But in terms of listed companies, under the listing rules, except for 5 companies that have grandfathered certain different voting class rights, basically you have to be equal with all the shareholders in terms of your rights. And this is the one share, one vote principle. The one share, one vote principle is an extremely sacrosanct rule in Hong Kong. So much so that recently we had a debate about whether we would allow Alibaba, and I think everybody knows which Alibaba we're talking about, to be listed in Hong Kong. At the end of the day, we felt that one share, one vote principle is so important that without studying the bells and whistles that we need to for minority protection, that we shouldn't allow it yet. Not that we are closing our doors to weighted voting rights or alternative voting rights. The issue is that we are actually studying that and enhancing our governance regime before we do that. Then the next question is, if we are so concerned about minority protection, can we not allow things like cumulative rights? That is, for example, a number of minorities coming together and voting their block of shares for the appointment of, say, a director or other arrangements to give them some sort of super rights. Our regulators and also our philosophy is that we would not allow those as well. Basically, everybody is one share, one vote. There's equality, and even the minorities themselves should not come together and lump up the rights. So the conclusion is that for private companies, there could be weighted voting rights, there could be alternative structures, but then for listed companies, we really strictly adhere to the one share, one vote principle, which we feel is very important for minority protection. So in terms of Hong Kong specifics, we have, as we mentioned, 1.3 million private companies, and for those companies, we actually impose the company's ordinance on that if they are Hong Kong incorporated. The first thing is alteration of articles. Under Section 91 of our law, we basically allow 5% shareholders to challenge any alteration of articles. Likewise, under Section 182, we allow 10% of our shareholders to block variation of class rights where they feel that there is some sort of unfair prejudice. In respect of financial interest, not in the best interest of the company, under Section 268, 5% shareholders could restrain a company from giving financial assistance to others if this is actually not in the interest of the company or not fair and reasonable. Under Section 552, 5% or such lower percentage under the Articles of Association could propose a written resolution along with written statement of no more than 1,000 words relating to resolutions. Under Section 566, 5% shareholders could call a general meeting. If we go on under the company's ordinance, basically also under 580, 2.5% or 50% of members could request a statement of no more than 1,000 words being sent to members in respect of business of a meeting. So you could imagine that if you are a disgruntled shareholder, you could actually muster up other shareholders and issue a statement which all shareholders would have to read and understand. Under Section 519, 5 members, and it takes only 5, or 5% shareholders could demand a poll at general meeting. This is entirely consistent with the one share, one vote structure in which we look at the number of shares as against the head count in relating to voting. Under Section 674, 10% or more of disinterested shareholders could veto a general offer. Under Section 388, Schedule 5, we introduced a new requirement for a business review. Basically, all shareholders should have information from the directors as to what is in progress in the pipeline and the views of directors on a forward-looking basis. So these are very powerful powers. But recently, we've actually added to the powers. Under Section 740, 5% or 2.5% of shareholders could actually apply to court to inspect the books and records of a company. This was taken up in a major case recently. There was a reorganization advised by an investment banker, and this relates to the Bank of East Asia Bank. And Elliott, which is a hedge fund, felt that this was not correct for the interests of the shareholders, and they went to court and they applied for papers. That case is continuing. Section 840 allows 100 or 10% of shareholders for good reasons to request our financial secretary to investigate the company's affairs. So all these are very, very powerful remedies that we have. But if you are an English lawyer, you would notice that one of the major stumbling blocks for minority protection is actually procedural rules called force and harm order. Basically, directors would have to be fraudulent or for other reasons before a shareholder, a minority shareholder, could take over legal action. So what happened is we now have a new statutory provision under Part 14 of the company's ordinance. Basically, anybody who's alleging fraud, default of negligence, default of breach of duties, or default of compliance with the company's ordinance can apply to court, and the court has very wide powers to protect the minority shareholders. Like we've heard in a lot of jurisdictions, the company's minding up provision is very important. This is significant power to Hong Kong court to deal with unfair prejudices, including to wind up a company. The interesting thing is in Hong Kong, as shown in a recent case called the Yongki case, which is a very famous goose restaurant. If you're ever in Hong Kong, you try that. I'm not advertising for them, and I'm not paid by them. But anyway, try them. Extends to unregistered companies with a Hong Kong connection. So the next thing that we look at is the listing rules. As I mentioned, aside from the private companies, the public companies would have to comply with the listing rules. Here, there is a thick booklet on it, and any topic would cover multiple number of days. All we want to hold in is on connected transactions. Basically, we've got very strict rules against the company trading with insiders and people connected with major shareholders. So therefore, we've got a connected transaction rule which extends to the insiders and their associates. In this connection, I welcome you to read a guide on connected transactions which ACSN has published on the topic. In there, I drew a little diagram which is actually very user-friendly. In terms of the Securities Futures Ordinance, this is at the highest level of minority protection in Hong Kong. Our security and futures regulator, called the Securities and Futures Commission, has already approached a new philosophy in terms of enforcement. They are now taking a much more active role for a listed company. So if there is some sort of misconduct type situation, and there are 6 types of those, the security futures regulator could actually investigate, obtain information, and also to bring in action either on a civil basis or a criminal basis. They are actually a power to be feared in Hong Kong. You would have to go to their website, www.sfc.hk, to see how active they are in enforcement. A particular area of concern is actually inside information for listed companies. Here, each individual officer in a senior position and directors could be liable for up to 8 million Hong Kong dollars personally. And the coverage of D&O insurance is very limited in this respect. So therefore, there are actually fines against the company secretary running into the $2 to $3 million range already, and that would have to be paid by the individual concerned. So overall, I would say that minority protection is taken very seriously in Hong Kong. We've got very strong statutory provisions, and that is why the company secretary profession in Hong Kong is strong. We've got 9,000 members and students, and we are advisors to good governance. Thank you.
Okay, thank you, Mohan. With that, we finish our list of speakers, and now we turn to taking questions that those who are on this webinar may pose. So I have received, let me see where I have received. Okay, the question I have here is that Siu Chuan from Malaysia mentioned that payment of directors' fees and benefits for public company requires shareholder approval. Does this apply to private companies? So Siu Chuan, do you want to take that, answer that question? Siu Chuan, are you there? Siu Chuan, Siu Chuan. Siu Chuan, Malaysia. Siu Chuan?
You've got me? Okay, I need to, this one back, right? Share. Okay, wait, this one. This one. Wait, got me? Yes. You got it? Actually, it's meant for a public company or company listed on the stock exchange. Did you get it? Can you hear? Hello? Yes.
We can hear you.
Yeah, okay. It's under provision 230, where it covers public company and listed company and subsidiary or listed company, where they need to get shareholders' approval at the general meeting for these payments of directors' benefits and fees. Hello?
Okay, thank you. So I now go on to the next question I received. Pak Hadi, the question is, in Indonesia, authority only regulates listed company or minorities' interests? Is that the case? Or does it regulate more than just the listed companies? The question is, in Indonesia, does the authority only regulate listed companies or minorities' interests? Okay, I see you now. You must, yeah, let's see.
Basically, the authority of Indonesia control all the type of shareholders, not only minority, but also the whole industry. That's the main point of bringing the stock exchange to the satisfactory level for everybody. As far as I know, that being able to accommodate everybody, I believe that every single shareholder has their own interest. As an example, like majority shareholders has their own interest. I believe as well that minority has their own interest. And combining these two, I think is very important for Indonesia, especially how we can develop the market together. That's the main point. But of course, as an industry, we acknowledge the minority do not have enough capacity for having a major decision, major change decisions. So that's why that we should quote unquote to protect their interest as well. So I think that's my answer. Thank you.
Thank you, Pak Hadi. I have one more question. This question is not a question, it's a request. Are the presentation slides from the Malaysian speaker, Siu Chuan, are they available for circulation to the... Siu Chuan, are your slides available for circulation?
Yes. Yes.
Okay, so we have the answer. The answer is yes. Thank you, Siu Chuan. Finally, the last question. The question says, it seems that the directors are also the majority who control the whole of the AGM. So this is a comment. Says it seems that the directors are also the majority who control the whole of the AGM. Anyone comment from our panel? I mean, share from your situation in your country. Is that the case? The additional comment came from the person who asked the question. It says, because most of the listed or private companies in Asia are family owned, they will appoint themselves as directors and receive the highest remuneration, and therefore they also control the general meeting. Is that the case in each of your countries? Let's go around. I would say that in Singapore that is the case. Pak Hadi, what's your situation in Indonesia? Are the majority also represented on the board and therefore they control the meetings?
So basically, if we take a look at in the annual report and also in the financial report, there is a numbers that was representing the total salary in 1 year. Recently, the regulators initiate a individual, what do you call it? Individual salary has to be explained or released or informed in the annual report. However, the major concern in Indonesia seems to be it's not in the right timing, because we believe that the government want to promote a less differences between all people, major people. We believe that being able to gather, I think, is much more important. However, the minority can actually propose an agenda in any case that they think that the salary is not really appropriate or exceeding their perspective or expectation, or their what do you call it, their knowledge. Because if we believe that if you put high numbers and the minority thinks that it's not right, so they could propose an agenda to evaluate the what they call it, the salary or whatever, or any agenda or any issues in the corporations through the mechanism of writing the letters that we already have in POJK number 32, 2014. Thank you.
Thank you. Any other views from the other panelists?
May I share
Which one is the situation in Malaysia the same, that the majority are often on the board?
Yeah, I mean, generally it goes back to the same point where one share, one vote. So in this nature of bigger, many of the not so big listed entity here, it's very much family control. Since it's one share, one vote, so in a way, they are on the board. They are also major shareholders and control, and they're able to put through most resolutions at general meeting. Having said that, the minority shareholders' voice are getting louder these days, but there is also some check and balance in the new act where, like I mentioned earlier, Section 230, where the benefits payable to directors are now included for approval. In the way, when the comment made was that they pay themselves very highly, and but there's some check and balance. And on top of that, there's a new provision on Section 231 where they can inspect, the minority shareholder, if you hold 5% or so in the voting shares in the company, could inspect the service contract. So there are some check and balance in place now. That's all.
Thank you. Mr. Rongrak, anything to add from Thailand?
In Thailand, we also have this kind of case because most of the listed company, the major shareholder will be a family. But according to Thai law, all the listed company which are listed on the stock exchange of Thailand, they need to have the independent director at least 1/3 of the total number of directors. That is the one of mechanism that the law enforce all listed company to follow. That means the minority shareholder will have the independent director who will act on behalf of all shareholder to protect the right of the shareholder in the company. So this will be the person who will balance and check the thing that do by the director who are come from the majority, who come from the major shareholder.
Thank you. And finally, from Hong Kong, Mohan.
Thank you. What happened is Hong Kong is a regulated market, as I've said, and what we have is a situation in which 70% of our market share is with family-controlled companies and sole enterprise. Now, surprisingly, it is a different ballgame altogether. Maybe 10, 15 years ago, the situation that you guys faced, we had. But what happened nowadays is that increasingly we require professional directors. In fact, we would have new corporate code amendments coming out for people to explain their relationship with the senior management who are family members. We actually have a lot of companies in which they go out to headhunters and they're paying very high fees to get the right sort of directors. Diversity mix is a major issue of our regulators. So in a way, the recent research that is coming in from Hong Kong is that the minority shareholder is actually in a good position when they actually invest in family companies and state-owned enterprises, because these people actually have a longer-term vision, and no longer are people who are just there because they are family members. There might be one or two, seriously. I mean, your eldest son or your heir, that we could understand. But the situation is that the board is now composed of a really good mix in Hong Kong. So that's my views in Hong Kong.
Okay, so to sum up, for private limited companies, it's likely to be the board are the majority. Listed companies, because of the codes of corporate governance and the listing requirements, you're likely to have a number of board members who are independent. Then the various countries that are represented, culture in each of these listed companies changes. We move towards what Mohan just mentioned about fewer family being on the board. We have one last question, that is the one share, one vote requirement a must for listed companies other than those listed in Hong Kong? That's the question that is posed. So I suppose we'll let Mohan lead off first to elaborate on whether they can have more than one share, one vote, and then we'll go around the rest of the panelists on this matter. The question being, is one share, one vote requirement a must for listed companies other than those listed in Hong Kong?
There are currently 5 companies in Hong Kong that actually don't have a one share, one vote structure. What happened is, I think around 20 years ago, 15 to 20 years ago, there was an opening up in which we were going to allow weighted voting rights. But what happened is, after 5 companies did it and everybody wanted to start doing that, the result was that it actually led to a bloodbath in stock prices. So here, for example, a company has one class share A, and then it issues class share B. But class share B actually have 5 voting rights, and it's the same price. And that actually goes to the family. So this happened in 5 companies, and we didn't have a good experience. And we had a backlash. We had dropped in the stock prices, and therefore, from that point, we have stopped that. But now the market is talking about new economy companies, Alibaba and other companies. So the issue now is no longer whether weighted voting rights will be allowed or not. The issue is what are the protections if we want to give that up. Right now, we haven't found the balance yet. Will we find the balance in the next 1 or 2 years will be the issue. So I can't say that weighted voting rights will not change. One share, one vote structure will not change in Hong Kong. It might change. And there's actually a serious discussion going on. But it is definitely going to be backed by corporate governance and the right sort of protection before that will happen.
The rest, Maisa, Malaysia?
All right, okay. Siu Chuan here. Generally, we also have this provision of one share, one vote. But in the new code on corporate governance, where they have introduced a two-tier voting for reappointment of independent director to remain as independent if they have exceeded 12 years as independent director. This one seems to have skewed a bit in the sense that it may appear to be no longer one share, one vote. Generally, the two-tier voting is for the large company where they need to have a first level of voting. Everybody could vote. That means the majority shareholders and the board supported the voting. And then the second tier would be their votes will be excluded. So it's purely minority shareholders have full say on the resolution. So this is a new two-tier voting in the code.
Thank you, Sichuan. Now to Mr. Rongrat from Thailand.
Okay, for Thailand, normally we have the same principle that one share, one vote for all listed company, but the company may also issue another class of share that we call preferred share. For the preferred share, the voting right of the preferred share can be different from the voting right of ordinary share. So in some case, the voting right of preferred share can be two share, one share for 2 votes, or one share for 5 votes possible. But most of the listed company in Thailand right now, they just have only ordinary share. That means all shares have equal right, that one share, one vote. That's all. Thank you.
Thank you, Mr. Rongrat. Pak Hadi. Pak Hadi.
Yes. Well, basically in Indonesia, we do not have that, what do you call it, specific setting for, let's say, 1 share, 5 votes, things like that. But in majority, we have what they call it 1 share, 1 vote. Another things that perhaps needs to be taking into account that in what we call it state-owned enterprise. In a state-owned enterprise, there has what they call it saham dwiwarna, 2 colors. Dwiwarna is 2 colors, which is red and white is our flag colors that belongs to the government. And there is a what they call it a special rights that attach in that particular shares. So especially in state-owned enterprise, there are a what we call it a special voting mechanism and special rights to the one who actually hold the saham dwiwarna, which is the government. Thank you.
And then in Singapore, it's for listed companies, 1 share, 1 vote. Private companies, you might still be able to have different class shares. Okay, thank you very much, everyone. It's been a long afternoon. So I think you'll join me in thanking all the panelists.
Thank you. Thank you.
And I should put in an advertisement for the upcoming ASEAN Company Secretaries Networks conference in Jakarta, November. Pak Hadi, you want to take over and advertise your conference now?
Okay, we will proceed. We hope that Ibu Grace will visit Malaysia. I think next couple of days. We are going to have a very good conference in Malaysia regarding with perhaps Mr. Suawe could actually explain this. Basically, we want to proceed our the first international ASEAN Corporate Secretary Networks in Jakarta. So please come to Jakarta in November. Thank you.
The date is 4th November, right?
Yeah.
So all those participants, if you're keen to visit Indonesia and learn more and visit the exchange and the regulators, keep the date for 4th November.
Yes. See, basically the topics, the major topics that will be discussed in November, it's about how we can mitigate the trending, what do you call it, issue on technology. We believe that technology now changed the way we communicate, changed the way we manage, and changed the way we publish information to the public. And due to this thing, we need to see a little bit further how we manage the informations with this new technology, especially with social media, with new disruption from technology in our business, and how we manage competition and so on and so forth. So I think it's a very interesting discussions. Please come to Jakarta on early weeks, the first week of November. Thank you.
All right, thank you everyone. Thank you everyone. I'm going to stop the podcast
Thank
now.
you. Thank you.
Thank you.
Thank you.
Thank you.